At this time, if you have a cell phone, if you would turn it to silent mode or turn it off. We do have a delay, possibly for 15 minutes. The attorney that's representing the case has got caught in traffic, the county attorney. Okay. All right. So we won't have a delay then. We'll be able to proceed. This time, we're going to review the minutes from the August 13th, 2024 meeting. I need a motion to approve those minutes as printed.
I make a motion to approve the minutes as printed.
You got a motion, need a second.
Second.
All in favor, let it be known by saying aye.
Aye.
The next item of business is application 2024-7-V. It's an appeal application by Bloom Parham LLP requesting to appeal the Community Development Director's July 30th, 2024 decision denying vested rights, entitling Pine Hill Investments, Ltd. from ordinance 2024-5 for PRD Planned Residential Development, Sheffield Park. Property is located in land lot 783, 786, 798, 802, 856, 857, and 859. District 3, located along the east and west side of Cartersville Highway, north of Sawmill Path. At this time, whoever is representing Bloom Par LLP, if you would come to the podium, give us your name and your address and sign our document there.
All right, yes, sir. My name is Andrea Pearson from Bloom Parham. My address is 310 Wester Hall Court, Sandy Springs.
You'll have 15 minutes to present the first case, and then we'll have any opposition after that come forward.
Okay, great. And I have a presentation.
One more thing.
Okay, sure.
Anytime we ask a question, we're going to stop your time, and you'll have the full 15 minutes to plead your case, so you're free to start.
Okay, great. And is there a place that I can see the timer? Or will you give me maybe a warning?
Yes,
Yeah,
Okay.
He'll give you 5-minute warning.
Okay, great. And I have a presentation for you all, if I may approach. Okay, so as you said, this is an appeal by Bloom Parham of the decision denying the vested rights for Pine Hill Investments for the Sheffield Park development. So on the first page of your presentation, you'll see this is a planned residential development for Sheffield Park. And the development summary, the PRD as I'll be calling it, it is a total acreage of 381 acres. It includes both a B1 section, which I won't really be talking about today, and a PRD zoning, which I will be discussing, 310 acres, tracts A and D, shown on the PRD plan. So the PRD plan approves 931 residential units. So tract A is 306 units, 102 acres, and tract D is 625 units, 208 acres. And I'll discuss this a little bit later, but part of the plan included typical lot sizes and setbacks, including 60-foot lots and 75-foot lots. So I've included an aerial kind of tax parcel map so you can see The property kind of straddles Cartersville Highway 61. So there's the tracks on the left and a tract on the right side. And the relief we're requesting here today, our decision, or our appeal, arose out of Ms. Littman's decision that Pine Hill did not have vested rights to develop Sheffield Park without application of the county's new ordinance 2405. So she found that that ordinance does apply to Sheffield Park due to her decision that Pine Hill did not have vested rights to the development of the property without the application of the ordinance. So we are asking you to overturn that decision denying Pine Hill's vested rights to an exemption from the ordinance and find that Pine Hill does have vested rights. So just a little bit of background in terms of the framework for vested rights under Georgia law. Vested rights protect a landowner where they have taken certain actions in reliance that are on the rules in place, such that if new rules are enacted, they cannot apply to the property at issue. So there are 4 different ways that a landowner can obtain vested rights under Georgia law: the issuance of building or other permits, the law in existence at the time that a properly filed permit application is made, formally and informally approved development plans, or official assurances that a building permit will probably issue. So with respect to categories 3 and 4, formally approved development plans and official assurances, there also have to be expenditures by the landowner in reliance on the formal plan or their assurances or obligations in pursuit of the development in order to obtain vested rights. So that one does require additional action in reliance on for those 2 categories of vested rights. And those are the 2 categories that we believe Pine Hill has obtained vested rights under here. Category 3, a formally approved development plan, plus expenditures and obligation in reliance, and official assurances regarding the property zoning and lot count. So with respect to the specific facts here that we believe entitle Pine Hill to vested rights, Pine Hill began the development process for this project back in 2004. They got an approval from Greta for the project. They then entered into a memorandum of understanding with the county related to traffic improvements. So going forward, saying we're working towards developing this, and the county agreed to a memorandum of understanding where Pine Hill agreed that they would pay up to $4.5 million for traffic improvements, which that was improvements for both Sheffield Park and the Sheffield Highlands development that I'm going to talk about in the next case. So these projects were sort of proceeding in tandem around the same time. So the lot count in the MOU was for 2,851 total lots. That was 1,920 lots for Sheffield Highlands and the 931 lots for this project. So we believe that that was an assurance regarding the number of lots obtainable for the property. The county in January of 2005 approved 3 different rezoning cases at the same time, approving the site development plan that we looked at just a minute ago. So the rezoning case 2005-03Z was 102 acres from R2 to PRD and allowed for 306 lot single-family subdivision. 2005-047, that was for the portion that's R2 to B1. And then 2005-05Z was 208 acres from R2 to PRD for 625 lots. So that's where the total 930 lot approval comes from, is from those 2 PRD residential zoning cases. And the conditions of those rezonings required adherence to the MOU that I talked about a minute ago. So basically the county, the board adopted and said, you have to follow the MOU as one of the conditions for this PRD zoning. And the rezoning formally approved the site development plan for the project and for the property. And then in 2018, the county also provided a certificate of zoning confirmation confirming the PRD zoning for the property and that the DRI review remained in full effect, so an assurance that the PRD zoning remained valid. So The next slide again shows you the site development plan that was approved as part of that rezoning. So it's important to understand that PRD is a special zoning category. Approval of a PRD necessarily results in the formal approval of a development plan under the category 3 that I talked about of vested rights. PRD zonings are site plan specific, meaning they zone property in accordance with the site development plan that's submitted at the time of the rezoning application. The UDO acknowledges this. It says that application for rezoning shall be supported by a written statement of intent and a site development plan, and sets forth specific requirements for the site development plan, including standard lot layout design. So as part of the rezoning, the Board of Commissioners looked at the site development plan and approved it as part of those rezonings in 2005. And the fact that more specific development plans or construction plans are submitted and approved later in the process does not take away the significance of that formal approval of the site development plan at the time of rezoning. So yes, you have to submit more detailed construction plans in order to get an LDP. That's not a novel concept. There is a next phase, but that doesn't take away the fact that a site development plan, the code calls it a site development plan, is approved at the time of rezoning to PRD, which we contend counts as a formal approval of a development plan under the vested rights that I talked about. So we believe here there was a formal approval of the rezoning through the rezoning to PRD with approval of the site development plan. There were also other informal assurances, including the MOU that had lot count representations and the zoning confirmation letter assuring the PRD zoning remained valid. And Pine Hill took action in reliance on those incurred expenses in reliance on the formal approval of the rezoning, the site development plan, and these other assurances. They spent approximately $122,000 in additional costs to date to pursue development, and they obligated themselves to the $4.5 million in the MOU for transportation improvements for Sheffield Highland and Sheffield Park. So we believe under those facts that the property falls under both category 3 for formal approval of a site development plan plus expenditures and obligations in reliance, and category 4 assurances regarding lot count in the MOU and the zoning certificate plus those expenditures in reliance result in vested rights. And we believe that Georgia case law specifically on point supports our position that the PRD site development plan does equate to a formally approved development plan under vested rights law. So the DeKalb County case versus Chapel Hill, specifically the plaintiff there applied for a community unit development plan. They called it something a little bit different, but was essentially the same as a PRD. And it included a detailed plan with specific areas for various land uses within the plan. Just like the site plan here had the PRD residential, the B1 commercial, and set forth the specific lot counts for both. And in that case, the community unit development plan was approved by the Board of Adjustments, and the plaintiff expended substantial sums in reliance on the plan. And the Georgia Supreme Court found that that approval in reliance was sufficient to establish vested rights.
And you've got 5 more minutes.
Okay, sure. So in that case was the seminal case relied on by WMM, which sets forth generally what vested rights are under Georgia law. In these cases, and the law says nothing about the rule, or that there's no rule that a preliminary plat is some sort of requirement to be a formal development plan. There's no requirement that you have to have a preliminary plat. Just like in Chapel Hill, it is enough to have a plan formally approved at the time of zoning in order to fall under category 3 of WMM and vested rights. And we believe that the application of the ordinance here will destroy Pine Hill's vested rights. Specifically, section 120.09 requires side entry garages, which will result in the extreme reduction in lot count here. There's specific lot sizes that were approved with the PRD plan that cannot work with side entry garages. They create substantial issues with both lot width and depth, and you also have to account for site setbacks and topography. So having to have a side entry garage creates a lot of, I guess, extra consideration that does not work with the lot widths that were approved with the PRD. And those lot sizes, the side entry garage makes the lot sizes that were approved possible to obtain. We believe that the ordinance itself is unconstitutional because it doesn't provide carve-outs for landowners with vested rights. It applies blanket regardless of whether or not you have vested rights and doesn't have a procedure in place to get an exemption. And it's also undisputed that it has retroactive application. The county no longer accepts PUD applications, so the ordinance has to apply to PRDs that have already been approved. So we believe that that violates the principles set forth in the Southern States decision. And it also doesn't give property owners the ability or time to perfect their vested rights. We also believe the ordinance didn't include specific enough detail regarding the legal notice to provide notice and opportunity of what the county was considering with these amendments to the ordinance. And we also believe that it goes beyond the county's power through the Georgia home rule powers. There's only certain things that counties can do and are allowed to do and enabled to do under the home rule. And we believe that the ordinance goes beyond the power to zone that's given in those rules. The design standards specifically, they are not, zoning is, you're allowed to zone and district property for various uses and have rules for the development and improvement of real estate, but we believe the building design standards go much further beyond that and overreach beyond what the county is actually allowed to do under Georgia law. We also believe the reversion section of the amendment is also unconstitutional and violates the ZPL because it violates vested rights. It downzones property without notice and opportunity to be heard and without following the ZPL, and violates substantive due process, procedural due process, and equal protection. So that is, I kind of sped through some of the stuff at the end because I wanted to make sure I had enough time to touch base on everything, but if you all have any specific questions, I can answer those, or happy to reserve maybe a minute or two if I have some for rebuttal.
You have a minute left.
I'll reserve that then.
All right. My first question would be, has your client paid any fees to the county?
So for this matter, they have not, they have the MOU, but they have, it's my understanding they have not paid that yet.
Okay. My next question would be, at the time of this approval, it's been nearly 20 years since this formal approval was given, and this county has changed significantly in 20 years. And as we know, time marches on and rules are made that are to benefit all of us. And as you stated in your case, that the term that you used, that they had a vested interest in this, I'm understanding where you're coming from with that, but also that just having a formal approval and making plans, I'm trying to tie the two together. Is there any way you could enlighten us on how that, other than a formal approval, would they have a vested interest?
So so formal approval plus expenditures is a way to get vested rights, which we believe we have. There's also assurances, official assurances that a building permit will likely issue, which we believe we got through the MOU and the zoning certificate, plus expenditures. So those are two different ways that you can obtain vested rights that we think exist here. And it's our position that once those vested rights accrue, you cannot take that away. that is the doctrine of vested rights. So that's what the law says, and once those expenditures happen in reliance on those, it's a prohibition against retroactive application of the law. So that's what we say is unlawful about the ordinance here, because it's retroactively trying to take away those vested rights, which we say that have been obtained here. So those things are in conflict, but vested rights, that's what vested rights protects, is the ability to obtain vested rights, relying on what the rules are, what your zoning is, and once you do that, the county cannot enact new rules to take away what you have relied on, and once those rights are vested. So that's what the doctrine is supposed to protect and does protect.
I have a question. Since the time of the approval, back 04, 05, has there been land disturbance or construction permits?
There has not been land disturbance. So that would be the next, that would be a additional formal approval of a development plan.
Okay. So since the original approval, then really that's just kind of bound from that point on till now? No other documents?
There is not a preliminary plat here. Right, correct.
Okay.
It's reliance on the formally approved site development plan at the time of rezoning,
Okay.
which we believe is sufficient under the law for a formally approved development plan.
I have one more. On the rezoning back in 2005, when it was changed from R2 to PRD, this is your complaint or vested interest that at this hearing, when this was changed from R2 to PRD, that gave you, your company, the right to hold the property in holding for all of this time?
That was the formal approval, and so once there were expenditures in reliance and obligations incurred in reliance, yes. So yes, once the second part of the test comes in, then yes.
Okay. Any other questions?
And two, the county has done away with the PRD back in 2018. It's been gone. And so you figure that you're grandfathered in on that all the way.
Yes, so actually I did have a slide on this that I didn't specifically hit, but the ordinance itself acknowledges that. So it says that the UDA recognized that any conforming properly currently zoned to PRD planned residential development district will be considered vested. So they recognize that even though they made it a legacy district, conforming PRDs were vested. So that is in the county zone ordinance.
We consider that as the vesting of.
Correct, because that was, I mean, the property obtained a valid zoning to PRD. So the fact that the county doesn't allow PRDs anymore doesn't take away that approval in 2005 to PRD. That is still a valid zoning for that property.
Mr. Chairman, I just wanted to
From
make,
now on, we can, you just get a development contract or whatever, it's good from now on.
Yes, I mean, our position is once there's reliance on that formally approved site development plan from the PRD, under the law, your rights are vested. That is our position.
I just wanted to make a comment about when the inactivation of the PRD came about. We're not saying that we're changing the zoning on the property. We're just saying that we recognize that that property is still zoned PRD. So it's not changing the zoning or anything, so I just wanted to point that out.
questions.
So you're saying that you can't build under the PR, the present PR,
Our position is that the new rules enacted by the county related to PR.
architectural rules?
Yes, the county changed its regulations in the ordinance related to PRD zoned properties. And it's our position that since we obtained vested rights prior to the county's passage of that ordinance cannot apply to this property. That is our position. So it's the application of the new ordinance related to PRD and otherwise to the property, and Ms. Littman's decision that the new ordinance does apply to the property, that's what we are here to appeal.
Thank you, ma'am. Time's expired. This time, if we have any opposition to this, we would ask that.
Mr. Chairman, just want to point out, there's been, if I can remember, at least one additional amendment to the PRD since 2005.
Please state your name and address.
Hello, my name is Ann Lippman. I'm the Community Development Director. My address is 5072 Laurel Glen Court, Smyrna, Georgia. I had prepared a memo that I sent out to the members of the Zoning Board of Appeals. Ms. Pearson and I are in agreement about the 4 standards, so I'm not going to go over those again. I just wanted to go over my process in reviewing this case, as well as over 100 PRDs that have been reviewed. Some I've reviewed just because I had time to look at a PRD. Some I've been requested a letter. So I've looked at a lot of PRDs. So with this one, I reviewed the history of the project, including the zoning case file, preliminary plat and construction plan submittals, applicable development inspections, as well as exhibits provided by Bloom and Parham. Below is a summary of the facts which I considered in determining that Sheffield Park is not vested. I'm not going to go over, I listed what the zoning cases are. Ms. Pearson did a very good job at doing that. All applications for PRD were required to submit an overall site development plan at the time of application. However, the zoning ordinance also required that a more detailed site development plan would be submitted for approval at a later date, consistent with the plan review requirements established by the county. The additional plan requirements set forth in the original PRD ordinance were as follows. Individual lot and dwelling sizes are to be provided when specific plans are submitted to the governing authority, with the provision that the maximum number of dwelling units per gross acre in a PRD shall not exceed 3.0 units. That is from the 2003 zoning ordinance. That ordinance also stated the application shall be supported by a written statement of intent and a site development plan. At the time of construction, a more detailed site development plan shall be provided consistent with plan review standards established by the county. The county's has a zoning ordinance, which is what this came from. The county also has a book called the Development Regulations, and the Development Regulations tells you how you're going to develop a piece of property. So I reviewed some of the development regulations. Section 3.2.3, which is plan review and approval, requires any developer of land within Paulding County's jurisdictional control shall first submit to the Community Development Department plats and construction plans as required by these regulations, and shall have been granted a permit consistent with these regulations and approved by the department prior to the initiation of development activities. The Development Regulations, Section 4.1.1, which is review of plats and plans required, states that all preliminary plats, construction plans, and final plats must be submitted to the Development Control Committee for review and approval prior to commencement of land disturbance or construction activities. In our records, there are none that indicate any submission of a preliminary plat or construction plans for this project, which would satisfy the above referenced requirement. Therefore, the general site development plan submitted for the rezoning case is not considered a formally approved development plan. Our records only indicate one submission for this project was a timber harvest notice dated December 6, 2021, and that is not typically a plan. That was just a notice that timber harvesting activities were taking place on that property. And it was those facts that led me to determine that this project was not vested.
Has there been any notices sent to any of the individuals that have received prior zoning notices, approvals such as this? Is it a standard procedure to notify them when the rules change?
I think you're asking, like our zoning ordinance has a requirement that adjacent property owners be notified of a change. Are you asking if those kind of notices were sent out, or if we,
Actually, I'm asking on the owner's behalf of this property that they had this zoning, and I know you probably have hundreds of cases like this. It's been mentioned that, my question is to clarify that if they come forward to submit new plans, at that time, you have no idea, this has been since 2005, you have no idea if they ever intend to go forward, but once they do come forward, then they're made aware of the new zoning regulations, and that's how we ended up here.
Mr. Chairman, I'll try and answer that. In 2005, when this specific properties were coming in for rezoning to PRD, there was notifications that followed all the standards from our ordinance and state zoning procedures requiring posted signs and legal notice notices in the paper. As far as what we're talking about today was an amendment as a text amendment to the zoning ordinance, the Title II zoning of the UDO. That would not be a specific, just one specific zoning. It would cover anything that would have been in that zoning district. That notification went out, just like in the newspaper. It was posted on our website. It was notified properly.
now I can also say that should someone turn in for a development plan or preliminary plat today and that property is zoned PRD, they are given a copy of ordinance 24-05, updating them of the new PRD requirements.
That's what I was kind of getting at. I know that if you have no idea if someone's going to move forward with a project, but I was just curious about that, and that answers my question. Any other questions for Ms. Lippa?
You've not changed, that's not changed the lot size or anything, then, I understand that, Chris?
We don't know because they haven't turned in any plans. We have, there was probably, I've done a lot of research on the Planned Residential Development District, especially since 2018 when we inactivated it. I believe we have about 100, ballpark figure, 100 zoning cases that zone property from PRD or to PRD. There's probably about 74, 75 projects. A lot of times it was multiple zonings that created one project. And some of them, if you look at what was submitted with the zoning site plan, they're very similar. Some of them are completely different. So some of them have less lots. Haven't compared to see if some of them have more lots, but there was a text amendment change to PRD, and Chris helped me out, 2012, that lowered the minimum lot size. So even though if you submitted a site plan showing 10,000 or 12,000 square foot lots, because of that text amendment, you would be allowed to do 8,000 square foot lots. So somebody who's coming in after they were zoned and after that text amendment change could completely redesign their site plan to meet that current PRD requirement. So that's why I put a lot of weight on what you have submitted today, meeting the current planned residential standards that have had several text amendments over time.
So the county is really, in essence, just trying to upgrade the architectural look of the subdivision, aren't we?
That is correct.
as far as
Because
the...
at the time, only there was a senior living section of PRD, and that was what was used as a basis for this amendment that we made in April. There were no building design requirements for PRD. There were some other zoning districts that had building design requirements, and with 100 zoning cases, 74 project totaling over 30,000 lots, that was a lot of land out there that's ripe for development.
So to clarify, the term is used loosely for PRD.
Well, it's a technical, planned residential development is a zoning district in our zoning ordinance. Other jurisdictions, some people call it a PUD, a planned unit development, some people call it a community unit plan, but in Paulding County, a PRD is a development that is based on the planned residential development zoning district.
In that form of the PRD, Chris had mentioned about the lot size changing, and when plans are submitted, I'm just trying to clarify because we got a lot of stuff going on here, that just because it's listed as a PRD does not necessarily make it a smaller house or a bigger house.
No.
It's whatever that they can sit within the
No,
setbacks.
there is a minimum, and Chris, since you have the book in front of you, if you want to share what those minimums.
In a PRD zoning district, a minimal lot size for, the minimal lot size for building lots in the development shall not be less than 12,000 square feet, and a minimal house size shall not be less than 1,400 square feet of heated area. However, the minimal lot size may be reduced to 8,000 square feet with a minimal house size of 1,600 square feet of heated space.
Thank you, sir, for clarification on that. Any other questions for Ms. Lippa?
Just for my knowledge, is there a stated time limit from the time the approval of the PRD till the time permits, construction, any of these other documents need to be done? Is there a time limit or no time limit?
Don't believe that at the time the PRD was adopted, there was a time limit. We converted from the zoning ordinance to the Unified Development Ordinance in March of 2022. Chapter 280 that governs the Planning Commission and how zoning cases are handled does have a reversion clause that gives people who own property in Paulding County 3 years to develop that property. There are opportunities for them to request an extension, and it was never my intent or the Planning and Zoning or Community Development Department to simply revert property back to R2 if it was zoned B2 after 3 years. We would initiate a public hearing such as this, that case would go back before the Planning Commission and the Board of Commissioners. So for anything zoned after March 22nd, 2022, I believe it is, there is a time limit, but for properties zoned in 2005, there were not.
Thank you.
Thank you.
Ma'am, I'm sorry I forgot your name. I have a question for you.
Andrea Pearson, yes.
I'm sorry. My question is that with the vested rights that you claim that you have, your client at this time is not willing to work within the parameters of the PRD. That you heard the question I asked Ms. Lippa about the lot size and that type thing. Some of the architectural issues that you mentioned earlier, you're saying at this time to move forward with the development of this project, your client is not willing to adhere to the new zoning ordinances that have been made. Is that correct?
I don't know if willing to adhere, it's our position that legally we are not required to adhere. And so therefore, We do not intend to adhere because we do not think we have to. And on the point of lot sizes, the PRD for this project specifically sets forth a minimum lot size of 8,000 square feet, which I believe is consistent with what he was saying is in the ordinance itself. Here, it's more, the position is the requirements, and while those design requirements sound like they may not be that big of an issue, when you actually put them on top of a PRD development plan that's already been approved, they do create a lot of issues due to the side entry garage. These, as you know, there's a lot of topography around here. Like, you can't get the widths that are in the plan with the side entry garages due to, you have to have enough room to swing the car around, you have to have side setbacks, front setbacks. It actually does create a lot of issues that on the face you might not appreciate, but they do make the PRD plan and the lot sizes and the lot counts set forth in the plan unattainable. And we think that we had a formally approved development plan that we should be able to obtain, notwithstanding the county's enactment of these new rules. And just on the point of Ms. Littman saying, well, there's additional requirement or additional plans that have to be submitted down the road, that doesn't mean that this isn't a formally approved development plan. So yes, you do have to apply for additional formally approved development plans, but that doesn't take away the significance of the PRD plan and the fact that PRD zonings are site plan specific. It's a very special specific category under Paulding County's ordinances that we think fall under category 3, and if you rely on them, you're entitled to follow that plan and not the new rules. And that's what our position is.
That's why I wanted your clarification on that, because there's some issues that, and I'm just making a statement here, that you go into a project planning to do one thing, and then the site won't allow you to do that, and I just wanted you to clarify that for
Right.
me. Thank you.
And I did want to, on your point about the process, and no, there was not individual notice provided to Pine Hill regarding the change in the ordinance. And we think that, at least from what we could tell, the planning, the packets for the public hearings didn't include the draft of the ordinance. And the notification that there were changes going to be made to the PRD or to the ordinance said nothing about any specifics about what they were going to be. So we do have issues with the way that the public hearing process went about for this and the notice that wasn't provided from our perspective.
All right, thank you.
Mr. Chairman, I just have two points to make. Just fact, there are house plans out there that would not impact widths on a lot with a side entry garage out there. That was something that was looked at when we were looking at these changes. Second of all, the notice out there did receive input from public that went out there when these changes were coming before the Planning Commission and Board of Commissioner, that we had inquiries from public.
Thank you. This time, is there any other opposition to this case? I need a motion.
I think that the explanation as to why they don't want it is, it's kind of unreasonable to me. I feel like that it's the parameters are still met, and I'll make a motion we disapprove it.
I need a second.
Second.
All,
Mr. Chair, if I may, just for clarification's sake. Mr. Hart, when you
Yes, sir.
say disapprove it, are you, is your motion to affirm the decision of Ms. Lippman or reverse?
Affirm the position of the county and Ms. Lippman.
All right, thank you.
Second.
all right. All in favor, let it be known by saying aye.
Aye.
All right, it's unanimous that the motion is carried to uphold Ms. Lippa's position.
Clarification, no to the motion.
No to the motion. At this time, moving on, case number 2024-8-V, appeal application by Bloom Parham LLP requesting to appeal the Community Development Director's August 8th, 2024 decision denying vested rights entitling Pine Hill Investments Ltd. from ordinance 2024-5 for PRD Planned Residential Development, Sheffield Heights, Highlands North. Property is located in land lots 1019 through 1022 and 1067 through 1070. District 3, Section 3, located along the east side of Shady Grove Church Road Post. At this time, would allow you to come forward and present your case on this.
Once again, Andrea Pearson, 310 Wester Hall Court. And I also have a
Stop the time. She's getting her stuff.
So this is an appeal of Ms. Lippman's decision denying vested rights for Pine Hill Investments for Sheffield Highlands North. So if you look at this first page, again, was a PRD approved by the county for Sheffield Highlands. And it also has a multiple tracks, both on different sides of the road. This one was 714 acres with B1 zoning as well as PRD zoning. The Track C and Track D were the PRD zoned parcels. Track C was 181 acres proposed for PRD for 545 units. And Track D was 458 acres proposed PRD zoning for 1,375 acres. So if you look at the page with the tax parcel map and the aerial, Sheffield Highlands, if you can tell, from the PRD, is a large development, and we are here today to appeal the decision that Sheffield Highlands North, which is just a smaller section of that Sheffield Highlands development, is not vested. So again, Ms. Lippman decided that Pine Hill did not have vested rights to development of Sheffield Highlands North without applying ordinance 2024-05, and we ask that you overturn her decision denying the vested rights to exemption for the ordinance. And again, I apologize, I'll try to be as least repetitive as possible, but these are similar cases or frameworks, but also want to make sure that we're discussing what we need to discuss. So again, the framework for a vested rights decision, there's the 4 categories: the issuance of building and other permits, the law in existence at the time the landowner properly files an application for a permit, formally and informally approved development plans or official assurances that a building permit must issue. And for the 3rd and 4th categories, you have to have expenditures in reliance or incur obligations in pursuit of development. And again, we believe that Pine Hill has vested rights under categories 3 and 4. Some of the facts are similar, but there are different facts here. So I want to make sure that we're appreciating and discussing some of the facts here. So in 2004, Pine Hill submitted for approval by Greta and received Development of Regional Impact Review and approval. The MOU that we discussed, the county entered into the MOU that set forth the agreement regarding traffic improvements for Sheffield Highlands and Sheffield Parks, which we just talked about. So the same MOU covered both developments. And Pine Hill agreed to pay up to $4.5 million towards the traffic system enhancements. And those payment terms were based on a specific lot count of 2,851 lots, which we believe was an assurance regarding the number of lots obtainable for the property. And then in January of 2005, the county approved rezoning case 2005-08Z, 458 acres from R2 to PRD for 1,375 lots. And then rezoning case 2005-06Z, 181 acres from R2 to PRD for 535 lot single-family residential development. Also, some commercial rezoning included in that as well. And the conditions, again, required adherence to the MOU, so the BOC adopted the MOU, and the rezoning formally approved the site development plan for the property. Again, the county issued in 2018 a certificate of zoning confirmation and confirmation that the DRI review remained in full effect. So we believe these were assurances that the PRD remained valid. And again, you have the PRD plan in front of you as the next slide. And then in addition, in 2020 and 2024, the Northwest Georgia Regional Commission confirmed that no DRI review was required, and all of the traffic improvements in the DRI contemplated went towards the development of the entirety of Sheffield Highlands, including Sheffield Highlands. We're calling it Sheffield Highlands North. And then in April 30th, 2021, Pine Hill entered into a development agreement with the city of Dallas to obtain sewer for the entirety of Sheffield Highlands. And they did pay a non-refundable $976,790 payment, obligated its successors and assigns to pay a sewer basin fee of $1,843 for each additional lot to connect to the sewer. So they did enter into a sewer development agreement for sewer for the entire development and paid money towards that development agreement.
Let me stop you there just
Yeah.
a moment. Who did they pay for this sewer?
The city of Dallas.
The city of Dallas?
Yes. So, but that was an expenditure in reliance on the PRD zoning in order to get necessary sewer to the project. Obviously, you can't have a project without sewer. So that was the purpose of that. So in this matter, Pine Hill has sold portions of Sheffield Highlands to builders. Those builders have moved forward to obtain additional approvals and have begun development. D.R. Horton obtained a preliminary plat for phases 1 through 6 of Sheffield Highlands and has also diligently pursued and obtained LDPs for phases 1 and 2 and the amenity area. And again, these documents show lot sizes with a minimum width of 56 square feet and lot sizes of 8,000 square feet. The property shares common amenity, HOA, and other components with these phases of Sheffield Highlands. And importantly, the preliminary plat for phases 1 through 6 requires a boulevard with a 94-foot right-of-way shown as Jessamine Avenue to connect the southern portion of Sheffield Highlands to the property such that it expressly contemplates development as part of the same subdivision. So if you see the next slide is that preliminary plat. And if you look in the pink, the pink pod, I guess pod 5, you can see kind of a larger road. That is Jessamine Avenue, which contemplates the connection from the southern portion. This is a picture of the preliminary plat for Sheffield Highlands South that has been approved, and that has a larger boulevard contemplating development of Sheffield Highlands North as part of the same project. And like I said, PRD is a special zoning category and results in a formal approval of the development plan because it cites plan-specific zoning the property in accordance with the plan at the time of submission of the rezoning, which the UDO acknowledges. And again, the fact that more specific development plans have to be submitted later as part of the county's code does not take away the fact that the county approves a site development plan as part of the rezoning. Like, that is just a fact. And we believe under the law, that is a formally approved development plan. And so here, there was the rezoning to PRD as a formal approval. The county's also gone on to approve preliminary plats for phases 1 through 6 and the LDPs for phases 1 and 2. So they are actively, there is active development pursuant to that LDP in Sheffield Highlands, the southern portion of that PRD plan. And there's informal assurances of the MOU and the county's zoning confirmation letter. And Pine Hill, again, has incurred significant expenses and reliance. They spent approximately $556,000 in costs to pursue development of Sheffield Highlands. They were obligated to pay $4.5 million in transportation improvements, and they paid the $976,000 approximate sewer development payment. And they are under contract with D.R. Horton to sell the Sheffield Highlands North in reliance on these approvals and the formal approval of the site plan. And we believe that these facts result in vested rights under Category 3 and Category 4. And Jason, are you okay with incorporating the discussion with respect to the Capitol Hill case from the prior matter? Or do you want me to?
As opposed to repeating it?
Correct.
I'm fine with incorporating.
Okay, trying to save us a little time, but incorporating my discussion of the Chapel Hill case from the Pine Hill Parks matter. And I would also like to point out that Ms. Littman has confirmed that the other portions of Sheffield Highlands are vested. So she found that Sheffield Highlands South was vested, and she also found that the west side of Sheffield Highlands was also vested. So she's found that, I guess, 2 out of the 3 portions of Sheffield Highlands are vested. She made the decision regarding the west side on May 10th and the Sheffield Highlands South August 8th. And Sheffield Highlands North is part of the same site development plan that was.
Let me stop you right there.
Sure.
May 10th of
May-
what year?
2024.
Okay.
So as part of her review of the PRD plans.
All right, thank you.
And it's Sheffield Highlands North is part of the same site development plan, and there's no basis under the law to find that part of a PRD zone property is vested, but another part is not. We also don't think that it makes any sense to impose entirely new design requirements on a later phase. That's going to result in disjunctive and inconsistent looks within the same development. So don't actually think that would go towards the considerations that the county is using to justify the ordinance. And again, we believe that the ordinance will destroy the vested rights, including the side entry garage and the lot widths that were approved. You know, our position is that the contemplated lot sizes will not work with side entry garages due to the issues with topography, setbacks, and make those the PRD zoning and the lot counts approved. And there are standard lot sizes that are approved as part of that PRD development plan with the rezoning. And again, with the preliminary plat, that approved specific lot widths for the southern portion. And Pine Hill relied on those, believing that they would be able to obtain similar lot widths for the northern portion. And are under contract with D.R. Horton based on those understandings. And we believe that the building design requirements, or they will destroy the budget for the cost of each of these homes. It's going to be incredibly more expensive in order to comply with the new design requirements, and contracts are made based in part on the calculation of what they think the house is going to cost. And when you increase that exponentially, that really harms the entire economics of the project and of the deal and of the contract. And again, we believe that the ordinance itself is unconstitutional for failure to carve out a way to obtain a vested rights decision, and it's undisputed the ordinance has retroactive application and has to apply to PRDs that have already been approved. and that the county did not give fair and adequate notice of what was being proposed in the, through the public hearing process or in the legal notice. And as I mentioned, it goes beyond the home rule powers to zone, with the building design requirements going well beyond what is considered and permissible as zoning. And we do not believe, which I think Ms. Lippman clarified, but we do not believe that the reversion sections of the amendment apply or could apply to this project because it was zoned to PRD such that you could not now apply those provisions to the project. So do you, that's...
I have a couple of questions. Going back to your facts and demonstration
Yes.
page. On April the 30th, 2021, your client entered into an agreement with the city of Dallas. And my question first is going to be to you, Chris. We're meeting here tonight on a county ordinance, correct? And anything that was done with the city is pertaining to sewer, not the development?
Tonight, we're definitely looking at vested or not vested on a PRD. As far as the sewer connection to this project, that was something, I believe it was agreed upon by the developer and the city, and I think Ann's going to address that.
Okay.
Okay.
All right. I'm
Can-
going to leave you 2 minutes. We'll let Ms. Lippa
Can
make
I
her
add 2 seconds?
presentation. Are you good?
I just wanted to add that the, well, I'll, you know what, I'll save it and I'll address it.
All right.
Mr. Chairman, I just wanted to make two clarifications and points that was brought up. As far as pointing out the parkway on the layout here where these pods were approved, this, in the last couple years, I think it was less than 2 years, there has been an amendment to our development regulations that require a second entrance if there's lots on a subdivision street and the lot count goes over 120 units. In order to get around that and have additional units, which is the pink pod and the, I guess, the kind of aqua green pod, they're right at 159 lots. That would require a multi-lane parkway regardless to reach those 2 pods, based just on our development regs.
Thank you.
The second thing too is when we're looking at PRDs, when the inactivation of PRDs came, that was, that would have any PRDs that met the minimal standards. We have pieces of PRDs out in the county that are below the minimum 50 acre standard out there that was required of all PRDs. There's pieces of them out there now. Those are inactive and will not be able to be developed under PRD unless they can come back in to somehow meet those minimal standards.
Thank you.
My review of this case, Sheffield Highlands, was fairly similar to that of Sheffield Park.
Please state your name for the
My
record.
name's Ann Lippman. I'm the Community Development Director, 5072 Laurel Glen Court. Start back over. My review of this one, I mean, these properties were zoned on the same date, January 25th, 2005. There are a lot of similarities, but I'm going to focus on the differences. And I agree that Sheffield Highlands Phase 1 does have a preliminary plat. I feel like it's me doing it. And when the applicant submitted the information requesting the vested rights status for this project, quite frankly, to be honest, that was the first time that anybody in Paulding County had ever seen the MOU with the City of Dallas. The MOU with Dallas calls out the following land lots that is part of the agreement where they paid the $900,000. It was land lots 1070, 1089, 1090, 1091, 1092, 1093, 1139, 1140, 1141, and 1142. The property that is shown as Sheffield Highlands North is land lots 1070, 1069, 1068, 1067, 1019, 1020, 1021, and 1022. The only overlap is land lot 1070, which that is where the property is split. Part of it is Sheffield Highlands Phase 1, and part is Sheffield Highlands North. The same cases that I went over about the PRD being when you submit it at zoning and then when you come back, apply to this property. There's a few differences. There was a timber harvest notice submitted at the same time in December of 2021. There was a concept plan submitted, and a concept plan submitted for discussion on March 28th, 2024. There was a copy of that concept plan in the information that I provided to you. That copy of a site plan is a copy of the 2005 zoning site plan with the approved preliminary plat for Sheffield Highlands 1 superimposed on the original plan. I took note, and I would like to point out that that does show that plans change from when you go from a zoning plan to when you get a preliminary plat approved, and just wanted to share that information about Sheffield Highlands and the MOU with Dallas. And can't answer many specifics of the MOU. I did confirm with the city of Dallas that that payment was made, and I'll be happy to answer any questions if you have them.
My first question would be that their agreement with the city of Dallas for sewer does not in any way affect the PRD and the requirements that are now on record. Is that correct?
I would say the county and the city have agreed upon territories. I don't have a copy of that map right in front of me. It was somewhat surprising that that was the first time we saw that memorandum of understanding, and when we received the confirmation that the payment was made. A property zone PRD, one of the requirements is you have to have sewer. There's no way you could have 3 units per acre. There's no way you could have an 8,000 square foot lot without having public sewer available. So in that way, they are related, but the fact that it is City of Dallas that they made the payment to, I don't know. That is what helped them get the project moving, because they had to have sewer.
Consider vested rights. They consider vested rights.
Yeah, and I read out the land lots because the only land lot in that agreement that was listed was 1070. And 1070 is not a land lot that's in Sheffield Highlands North.
I believe our next question is going to be to Jason, if you could help us with this. The whole complaint or application is based upon vested rights. Without anything being done at this time as far as in the field, that's a whole nother right that they could have. My question to you is, they entered into an agreement with the city for sewer, as Ms. Lippa's already explained. That agreement,
But I will point out that that agreement was for Sheffield Highlands Phase 1, not Sheffield Highlands North that we're discussing today. We do not have, a copy of that agreement was applied for this, but I did not believe it applied to Sheffield Highlands North because the land lots listed in the MOU where they made a payment to Dallas were not part of Sheffield Highlands North. And in the previous case, like with Sheffield Highlands Park, the only thing they've submitted was a concept plan. They do not have an approved preliminary plat. They have not applied for or received a land disturbance permit or a final plat.
So the fees that have been paid are for a separate
Yes.
development?
The fees that were paid were for Sheffield Highlands Phase 1. My letter was for Sheffield Highlands North.
Is phase one considered that south and west?
That's the
Area?
south portion.
South por-
The
okay.
west portion, another entity entirely submitted a preliminary plat
Right.
prior to April 9th.
And that's what was entered in, this payment to the city of Dallas?
For Sheffield Highlands Phase 1.
Right, not
Is
north, which is the
my
appeal.
reading of that MOU.
Okay.
That's this top, this page, this top area was not included.
Okay.
Except for one little piece down here. In Dallas. This is the piece that's not vested in our.
And if I could take this opportunity, you may receive a letter saying you're vested, but our development regulations have some time constraints. Once you get a preliminary plat approved, a developer has 12 months to get construction plans approved. And once you get construction plans approved, you have 12 months to start work. There is one opportunity for an extension to be granted by me as the community development director.
And when did that start?
That's been in the development regulations since they were adopted in 1999.
And that time's passed?
Well, for Sheffield Highlands North, they have
Not
not
done,
received a
right.
preliminary plat.
Right. Okay.
Anything else from Ms. Lipa? Any questions? Thank you.
All right, so on the issue of the sewer development agreement, I just want to clarify that the MOU that we refer to is with the county. So the MOU for transportation was an agreement with the county, which the county did approve by including adherence to the MOU as a condition of zoning. The development agreement for sewer was with the city. So just want to make sure she used the word MOU, which I believe was slightly inaccurate. The MOU was for transportation with the county, but the sewer development agreement was with the city. And the importance of the sewer development agreement with the city is that that was an obligation and an expenditure in reliance and pursuant to development of the property. The fact that it wasn't with the county doesn't take away from the fact that it was something done to pursue development. And we've submitted an affidavit from Mr. Barrett Howell, who is the general partner of Pine Hill Investments, and that Pine Hill entered into the development agreement with the city of Dallas in order to obtain sewer service for the sewer Sheffield Highlands development. Pine Hill entered into the development agreement for the benefit of the entirety of Sheffield Highlands, ensuring the provision of sewer service to the property. And under the development agreement, Pine Hill paid the non-refundable fee of $976,790 and obligated a successor and assigns to pay the sewer basin fee. So that the development was for provision of sewer to the entirety of Sheffield Highlands. And there was some overlap, as Ms. Lippman pointed out, in the land lots included in the description in that agreement.
So you're saying that the sewer development agreement was for the entirety of the property, including
It provided-
north,
correct.
not Ms. Lippman's of the first phase? Is
That I will agree with her that it does mention phase one. I'm not disagreeing with her there, but that the intent and the purpose of the agreement was to provide sewer to the entirety of Sheffield Highlands, which it does. So that's how Sheffield Highlands, well, north and south, is intended to get sewer for the project.
Can you tell us how this amount was obtained? Did they use lots, or is it an impact fee?
So it is based on a lot.
I noticed in the last part of it, which is typical, you pay an impact fee, and then later, when you build the house, you do a tap fee that would be in addition to the impact fee, and that's what I'm trying to,
So there was a total number, and then it was divided by a lot number expected. So it was essentially
in the
an estimate.
the projected lots for the entirety are for phase one.
It says, it does say phase one.
And if I could just point out, that's why I read the land lots. I read that development agreement with, the agreement with Dallas. If I used the wrong nomenclature, I apologize. But I read through that agreement several times, and the land lots, the only overlap is land lot 1070. And a portion of land lot 1070 was included in Sheffield Highlands Phase 1. And then the balance of it is in Sheffield Highlands North.
Correct. And I just want to make sure that it's clear that a statement was made that nothing was being done. But Sheffield Highlands is being actively developed. So the southern portion of Sheffield Highlands is being actively developed. There's a preliminary plat, so that is a formal site plan, and there are also LDPs. So there is active construction in Sheffield Highlands South, which we think vests further the entirety of the PRD site development plan for the property and its PRD zoning.
Do you know what land lots are actually in that phase?
In terms of phase one, I don't have those exact numbers for the
So the
Sheffield Highlands South. When we're calling it Sheffield Highlands South and North, I don't have those exact lots right in front of me, no. I might be able to find them.
While you're looking at that, for clarification, it's almost like this project is broke up into three pieces. We call it, and sometimes you're calling it phase one, and then the others, it's the south, and some, it's the north. And can you give
So
clarification?
to clarify, I don't think the development agreement with sewer said the word phase one. So I think that is creating some confusion. We've been trying to call the portion of the property that we're talking about today Sheffield Highlands North, and then the portion directly south of that Sheffield Highlands South, and both of those were a part of I think track D in the PRD development plan, and then the I guess maybe Sheffield Highlands West, which is a additional portion, a separate portion of the property.
But was included in the original PRD.
Correct. All three of
All
those
three
pieces
phases
were
in the-
included in the
right.
original PRD. So that is our position that, and Ms. Lippman has acknowledged that Sheffield Highlands West and Sheffield Highlands South are vested. So it's our position that there's no reason or basis under the law to find that 2 out of the 3 portions of a PRD development plan are vested, but one is not.
And 2 of the 3, excluding what we're talking about tonight, are underdeveloped, or there's been dirt moved on those,
On south,
on south, okay?
Yes.
But nothing on the north.
correct.
Right.
The north does not have a
Does not have
preliminary
any,
plat
right,
or
other than
LDP.
a tree. Timber harvest notice, so it's sitting there, okay. And is this the one, is north the one that's currently for sale? Is
It's under contract.
under contract, okay.
Based on these prior approvals and assurances.
Chris, is there currently a development permit tied to these tracks? I'm trying to get, we're talking about a lot of property here, and to make sure that we make the right decisions, that, and it's very confusing that,
Yeah.
let me take a attempt to answer that question. Sheffield Highlands Phase 1, which is what I use the names that engineers submitted for the projects, and then I use the names that when people ask for a vested rights letter. I don't know why it's not Sheffield Highlands Unit 1 and Unit 2, or Sheffield Highlands North and Sheffield Highlands South, but I will tell you what has a permit right now. Sheffield Highlands Phase 1 received a preliminary plat for 530 lots. Sheffield Highlands Unit 1, which is 93 lots, received a land disturbance permit on October 28th, 2022. Sheffield Highlands Unit 1, Phase 2, which is 154 lots, also has a land disturbance permit. I'm afraid I do not have the date, but it was prior to April 9th, 2024, when we made the change to PRD. Phases 3 through 6, because they had a preliminary plat and the agreement from Dallas and verification that the payment was made, that is why I determined that that was vested. Sheffield Highlands North,
Let me stop you just
Okay.
a moment. Do you have a land lot on that particular tract?
for Sheffield Highlands North, yes. There are 8 land lot 1070, 1069, 1068, 1067, 1019, 1020, 1021, and 1022. I will agree that 1070 is split between Sheffield Highlands Phase 1 and Sheffield Highlands North, with the majority of it being in Sheffield Highlands North.
Or is that what y'all have record of, the land lots?
So I was at fault. I have, our application includes 1019, 1020, 1021, 1022, 1067, 1068, 1069, and 1070. Is that consistent with
Yes.
yours? Yeah.
Yes. All right, sorry, Ms. Lipa, to interrupt you. You can continue with what you were. I just wanted to clarify
Yeah.
that we're moving in the right direction.
I don't think I have anything else unless you have any questions, because that was just given what in Sheffield Highlands Phase 1 has approvals, and Sheffield Highlands North does not have a preliminary plat, does not have a construction plan approval, does not have a final plat. The only thing that's been submitted was a timber harvest notice, which isn't a permit, is just a notice that you're harvesting timber. And they submitted a concept plan that was submitted to the Development Control Committee, which is a group that's comprised of representatives from Community Development, Department of Transportation, Water System, Environmental Health if needed, Fire Marshal if needed, to review and get comments. And the group met, and I can't recall what the comments were, but nothing formally was submitted for Sheffield Highlands North.
Looking back to your notes, there's not a page number on this one, but it's speaking about the May 10th, 2024.
I'm sorry, can you give me one sec?
It speaks of Ms. Lipa's determination that High Shoals Road track was vested on the 8th of August, 2024. Ms. Lipa determined that portions of the Sheffield Highlands included in the preliminary plats were vested. And Sheffield Highlands North is part of the same site development. Is that correct?
Can you, can you clarify your question?
That all of these that are vested, which I'm seeing two that are vested,
Correct.
Yes.
and the third one is saying that Sheffield Highlands North is part of the same site development.
So, yes, so that is, I think maybe let's all get on the same page with our nomenclature. The May 10th, 2024, that is a determination that the Sheffield Highlands West,
Which is not the name that it goes by.
okay, so the High Shoals Road Tract?
Yes, that is the proper name.
Okay, so High Shoals Road Tract.
And you're calling it west.
I was just trying to be directional, but maybe,
That's not the right name.
okay, so as I said in the PowerPoint, the High Shoals Road Tract.
All right, and then the next one is,
So that was Sheffield Highlands, the, what she was calling Phase 1.
is that what you've got it labeled as?
Yes, that is what the applicant submitted the name as, Sheffield Highlands Unit 1.
Unit 1, not Phase 1, correct? It's Unit 1, and then it's Phases 1 through 6, showed in the preliminary plat, that those were vested. And our point is that Sheffield Highlands North is part of this same PRD site development plan as those properties. So that is what the point I'm making here is the rezoning in 2005 approved, the county calls it a site development plan under their code as part of the PRD zoning. And the Sheffield Highlands North is part of the same PRD site development plan as High Shoals Road and Sheffield Highlands Unit 1 that have been determined to be vested.
The north section that you were just speaking of is contained in the land lots that I questioned just a moment ago.
Those are the land lots subject to our appeal.
Okay.
And you consider all of these as one, west, south, north, but or one under the PRD, right? One
Correct.
tract of land, but for y'all, they are separate because north right now is under contract to be sold, and the other two are going forward under development, right?
So to clarify, they are all, if you look at the first page, they all are in the same PRD site development plan.
Right.
And the portions of them have been, I guess, they are in different stages of development and of negotiating contracts for the sale. So some of them for Unit 1 have closed, and Sheffield Highlands North has not yet.
Right.
Any more questions?
And as Ms. Lippman said, in north, there's been no other site plan, construction plan, any,
Correct.
Right.
The only thing we've submitted is a timber harvest notice and a concept plan.
Right.
Which we do not consider the same as a preliminary plat.
right.
Especially since the concept plan submitted was the exact same plan as on the zoning plan from 2005.
And that is why you
That was
vested
part of-
two
that was
and
part
did
of
not vest the
My
third.
consideration, yes.
Which we obviously disagree with Ms. Littman regarding what's the cutoff for a formally approved development plan. We do not believe that a preliminary plat is required. We believe under the law, the PRD site development plan is sufficient to be a formally approved plan under WMM.
Thank you. Is there any opposition to this other than what's been stated? Yes, sir. Please state your name and address.
Tom Matthews, I live on High Shoals Road. My only concern is.
One
my
thing,
parents-
sign the book.
My only concern is the cemeteries over there. What are they gonna do about the roads running by the cemeteries? My parents are buried over there, my grandparents are buried over there. And there's a sign saying they won't run right by the cemetery. I got a picture how close it won't run the road. That's what I got to say.
Mr. Chairman, I can address that. As part of the development out there, We have had the developer prepare archaeological study and establish the limits of the cemetery of Shady Grove Church, and I'll be glad to provide that.
Yeah, that'd be please.
Let me give you one of my cards, Mr. Matthews.
Can I come up there? This is my grandfather's grave, and that's where they don't run the road.
Thank you, sir.
Any other opposition at this time? Please state your name and address and sign our sheet.
Okay,
please.
my name is Nicole Traverse. I live off 282 Shoals Trail in High Shoals. My question is the traffic plan for High Shoals, because we are already pulling out into a very dangerous intersection, and I'm a mother of a 2-year-old, and I have an infant on the way. And every day I'm scared to pull out on High Shoals, so I have a question about what the traffic plan is for the area.
Mr. Chairman, the portion that's developing on the west and the south, that's already been approved and everything. There was some traffic that you might could get some information from the Paulding DOT.
Okay.
What they're considering tonight is not, can you build houses out there? And what the traffic is, if this particular developer on another section of that track should have to build a house to meet a new standard for the house design.
Okay, so we can ask someone else.
But let me give
Okay, thank you. Okay, yeah, 'cause we have questions about like schoolings too. That's a lot of homes in our school system. We're educators. We're not really prepared. So we'll reach out. Thank you.
Anyone else?
My name is Emily Greenway. I live at 87 Principal Point, Dallas, Georgia. My question is, as a Paulding County school teacher, how are we going to address the amount of students coming into the county that's already overcrowded with all these new homes?
I don't have an answer for that. I'm just here on the appeals board, and that's one of the reasons I believe, and I'm just going to say this, that we're here tonight talking about developments in this county that have been submitted, and I know that we all have concerns about things of that nature, but I'm in no way able to address those
Okay.
for you.
Thank you.
Anyone else? This time, if there's no other opposition or statements to be made, we're going to move forward.
Mr. Chair, if I may make a comment about that, I just want to remind the three of y'all, I don't pretend to assume that you've made a decision either way, but I want you to know that it is within your discretion, should you feel the need to continue to digest the factual information and the arguments that have been put forward tonight. It's within your discretion to table your decision to the next meeting in case you need time to further digest what's been put in front of you. I'm not suggesting that you do that. I'm simply letting you know and reminding you that that's an alternative that you have.
Thank you very much. I'm trying to absorb the first part of it, and here it's all piled on. I knew this would be there's a tremendous amount of money that's been spent and a lot of hours going into it. And I want to be, anybody that knows me, I want to be the fairest man and the most truthful that I can be to any situation, and upholding what the county's done, and at the same time giving the applicant a fair opportunity as she has presented their case. But at the same time, there's a lot of issues, and I'm just telling you where I'm at, that need to be weighed out. That I don't believe we can come in here in 15 minutes and make a monumental decision on it. I agree that the first part was pretty cut and dry, but this second part, there's a lot of work that's went into this, and just to simply sit here and say no or yes, I think that as the good lawyer has given us opportunity here, we'll discuss it and let you know.
Mr. Chair, if you're inclined to do that, I would recommend that someone make a motion to table your decision until the next scheduled ZBA meeting. Mr. Chair, I would suggest that if y'all need further time, that you do a motion to table that to a later meeting, or you make a motion either way.
Mr. Chairman, I think our attorney's got a good idea there, where this is a lot of information for us to digest and try to make a decision on, and I feel like that we should possibly mull it over for at least till the next meeting. I'm going to make a motion that we table this decision until the next meeting.
Chris, I've got a motion on the floor to table this to our next meeting. We don't currently have a meeting scheduled for this year, correct?
Actually, the next meeting would be December the 10th. If you table it, it would go to that schedule, which is a scheduled meeting. We do not have any other applications at this time, if I remember. And so this would be the only application on that December 10th meeting.
On the motion that's on the floor, I need a second.
I'll second.
All in favor, let me know by saying aye.
Aye.
We're all in agreement that this will be tabled until the December 10th meeting, so we can review it further. Thank you for coming, and good night. Let it be known by getting up and leaving.